The Salamanca man who raped and killed a woman in 1999 will not serve any additional time in state prison for violating his parole in July. Edward Kindt left his halfway house across the state, drove to the southern tier, and stayed there for almost a week before anyone found out.
The punishment was 7 days in jail, and since he has been in jail since his arrest, he will return to his halfway house. Some elected officials are now saying this is just a slap on the wrist. To talk more about this, right now we're joined by legal analyst Terry Connors. Terry, thank you so much for coming in this afternoon.
Good afternoon.
So first, let's just begin with your overall reaction to this situation. What do you make of a 7-day arrest?
Well, you've put your finger on the controversial new aspect of the less is more statute. It was enacted as part of a package to try to integrate prisoners into society faster, but it has backfired in some circumstances. So the judge in this case had limited discretion. It was a technical violation. The battery went dead. He wasn't at his place of where he was supposed to be. It wasn't a crime, and that's why it was 7 days.
We got the transcripts from this hearing that took place actually during the month of August, and in those there was the argument that you could see from both Kindt's attorneys and, of course, the state saying, well, he may not have fooled with his ankle monitor or maybe cut it off or something as deliberate as that, but instead he just allowed it to die, but then it also allowed him to escape and be gone for 6 days undetected. And yet that still is not a crime.
Right, it's not a crime under the penal law.
Because it's a technical violation. Can you explain the difference between a technical and a non-technical?
Sure, best by doing that with examples. So a technical violation is someone who misses curfew, someone who disobeys a regulation, someone who has problems with their monitors, their GPS monitors, things like that that would not constitute a crime under our penal law. But if it's a crime, if it crosses that line, it becomes a crime. The discretion of the administrative judge broadens, and they can do a lot with respect to returning him to prison to serve out the balance of his sentence.
What do you make of the 7-day sentence? They released him back to the halfway house because he was in custody during that time.
Yeah. Generally, when you are sentenced for any term of imprisonment, you get credit for any time that you've already served prior to the determination of the judge. So what happened is he had already served that period of time. The judge was limited in the discretion that he or she had available, and it maxed out and he was able to leave.
Is the judge not able to, despite that, and I think I know this is maybe a rhetorical question, but is the judge not able to take into account the fact that this man, who is not supposed to be anywhere near the victim's family, was in town for almost a week undetected by the victim's family? That in and of itself should be a crime. But it's not in this case.
So the administrative law judge has a lot of discretion, but it has to be on the basis of the proof that's submitted. Each side is represented. There are commissioners that provide testimony as well, and ultimately the judge makes the call. So in this case, I know it was a controversial one because of what happened in 1999, but it was the right call.
I know you were differentiating, what makes a violation technical. What do you make of some elected leaders calling for parole reform now?
Well, that's been a cry that has been heard along with the bail reform, because they run basically on the same parallel lines, releasing someone into society too early who's committed a crime, releasing someone who's been charged with a crime and accused. And that's been debated every year, year after year. And so the one side of the debate says, well, we have too many people in prison and it doesn't help rehabilitation. You have to be a little bit more liberal. And that is less is more. The other says, no, any slightest violation should prevent them from being released on parole, and there should be maximum terms of imprisonment. That's been debated since I started as a lawyer.
Do you think that judges want that discretion back, or do you think, and I know this is maybe perhaps a less is more argument for this question that I'm going to actually be asking you, but do you think they want that discretion, they want that power and control back to be able to make decisions based on someone's criminal history, their likelihood of showing up to court, so on and so forth? Or do you think some of them use this as a crutch to say, hey, our hands are tied here?
So that's a great question. And the answer is some of them definitely want the discretion because they want to rule their courtroom. They feel as though they have the best equipment to be able to make the right decision. They're intelligent, they've got experience. And there are others that say, you know what? I can defer to this legislation, I can deflect criticism, and maybe it's best if I don't have that type of power.
All right, legal analyst Terry Connors, thank you so much for coming in this afternoon, sharing your insight with us.
You're welcome.
Appreciate it, Terry.